Hi everyone, my name is Olani Oyindamola David. I'm a sensei at sensei.ng, and today we're going to be talking about fundamental objectives and directive principles of state policy. Without further ado, let's get right to it. Okay, so fundamental objective and directive principle has some form of background in the Second World War, where between 1939 and 1945, where we witnessed a lot of evils from Adolf Hitler and Germany. And so it became necessary to further guarantee the fundamental human rights of citizens and the human race. And the first constitution that included fundamental objectives and directive principles was the Irish Constitution of 1937, followed by the Indian Constitution of 1950. And so the inclusion of fundamental objective and directive principles, also known as socio-economic and cultural rights, also known as second generation rights, in Chapter 2 of that 1979 Constitution was a radical and a welcome innovation in our constitutional history as a polity. And so, according to the Constitutional Drafting Committee that drafted the 1979 Constitution, the fundamental objectives are a set of programmatic and aspirational ideals and ultimate objectives which the state should seek to achieve, while the directive principles are the signposts or the path to the realization of those objectives. And also, according to the Constitutional Drafting Committee of the 1979 Constitution, the rationale for the inclusion of those fundamental objectives and directive principles of state policy is to secure the welfare of the citizens of Nigeria and also to protect the polity against personal aggrandizement of politicians, and also to protect against the crude and primitive acquisition of undue wealth by the politicians. And so in the 1999 Constitution, especially or in Chapter 2 of the 1999 Constitution, specifically from sections 13 to 24 of that Constitution, it provides for these objectives and these principles. Section 13 provides that every citizen, every person, every organ of government shall conform to, apply and observe the provisions of Chapter 2. Section 14 is on government and the people. Section 15 is on political objectives. Section 16 is on economic objectives. Section 17 is on social objectives. Section 18 is on educational objectives. Section 19 is on foreign objectives. Section 20 is on environmental objectives. Section 21 begins with the directive principles of state policy. Section 22 provides for the obligation of the media. Section 23 is on ethics, while Section 24 rounds up with the duties of the citizens to the state. And a major feature of all constitutions that provide for fundamental objective and directive principles is that they always or they usually subject or oust the jurisdiction of their national court to apply or interpret or enforce the provisions of such fundamental objective and directive principles of state policy. And our constitution is or has also joined the bandwagon. If you look at section 6, subsection 6C of the 1999 Constitution, it is what we know in law as an ouster clause, which makes such matters the object of which is the enforcement of fundamental objectives and directive principles of state policy to be non-justiciable. And you might ask, what is the meaning of something or a matter being justiciable? Justiciability is a legal concept that talks about or relates to the suitability or the appropriateness of a matter being heard in a court of law. And for a matter to be justiciable, there must be a real dispute between the parties, the matter must be ripe, the court must have jurisdiction among other things. And we have already established that by virtue of section 6, subsection 6C of the 1999 Constitution, such matters are non-justiciable. Now, if you have been paying attention from the beginning of this video, section 13 on one hand says that all organs of government, including the judiciary, the executive, and the legislature, must conform to apply and observe the provisions of Chapter 2. And then on the other hand, Section 6, subsection 6c says that such matters are non-justiciable. That is, they cannot be heard in a court of law. So to your mind, I'm sure that there is a possible or apparent conflict between both provisions, but that conflict is more apparent than real. Because in the case of Archbishop Okoje, an Attorney General of Lagos State, the court, amongst other things, had to decide whether there was indeed a possible conflict between these two sections. The court held that Section 13 cannot be deemed to interfere with Section 6, subsection 6c, because all Section 13 purports to do is that the judiciary must interpret the other provisions of the Constitution in light of Chapter 2 of the 1999 Constitution. This does not mean that he has the power to make a decision on whether an organ of government has conformed to Chapter 2 of the 1999 Constitution. So there's a difference. The extent of Section 13 is only to the end that the judiciary interprets other provisions of the Constitution in light of Chapter 2, but they are not empowered to make a determination as to whether, any organ or department of government has acted in line or in conformity with Chapter 2 of the 1999 Constitution. So there are other cases that also talk about fundamental objectives and directive principles of state policy. And as we will soon establish, these cases have adopted a restrictive approach to the interpretation of fundamental objective and directive principles. Before we examine these cases, perhaps if we examine the arguments of proponents of the non-justiciability, you would better understand this restrictive approach. Now, proponents of the non-justiciability of Chapter 2 argue that civil and political rights on one hand and socio-economic and cultural rights on the other hand are negative rights and positive rights respectively. And to this end, negative rights involve much more concrete examples or instances of infraction of citizens' rights, while positive rights involve a positive duty on the state to achieve these socio-economic and cultural rights. And they argue that the resources at the disposal of each state varies, and each state might not be able to achieve these socio-economic and cultural rights. So it is necessary to make such socio-economic and cultural rights non-justiciable. As a matter of fact, an extreme view that was canvassed by Professor Abiola Ojo, an eminent legal scholar on constitutional law, was that such socio-economic and cultural rights have no place in national constitutions and only belong in the manifesto of political parties. And so, going back to the cases, they have told the line of these proponents of the non-justiciability, because they've severally held that Chapter 2 is non-justiciable. However, there are a crop of cases that have decided whether the non-justiciability is indeed absolute, or there are some exceptions, or there are some leeway that will provide for those rights being justiciable. So you have two cases: Attorney General of Ondo State against Attorney General of the Federation, and Olafisoye against Federal Republic of Nigeria. So in that case, the relevant question, or the question in issue, was whether the National Assembly had the power to make the ICPC Act pursuant to their general powers under Section 4, subsection 2 of the 1999 Constitution, especially as corruption is not an item listed in either the concurrent or the exclusive legislative list. And so Nikitobi JSC, an eminent jurist, held that the non-justiciability captured by Section 6, subsection 6c is neither sacrosanct nor absolute, as there are some leeways that can provide or that can make such matters to be justiciable. Now, Section 15, subsection 5 of the 1999 Constitution, which is in Chapter 2 of that same Constitution, provides that the state shall do everything within its power or shall curb corruption. And so, the court held by Nikitobi that by a community reading of Section 4, subsection 2 on the general powers of legislature, Section 15, subsection 5 on the fundamental objective, Item 60A, Item 67, Item 68, Part 2 of the second schedule of the 1999 Constitution, and Section 2A of the Part 3 of the 1999 Constitution, corruption or the ICPC Act can indeed be made, and that particular part of Chapter 2, which is Section 15, subsection 5, can now be justiciable. So in essence, what the court is trying to say is that if there are other provisions of the Constitution which are in line with the provision of Chapter 2, they can be read together to make it justiciable. Now, indeed, if you look at the beginning of Section 6, subsection 6C, I think the beginning line, it says that expressly as otherwise provided. So it makes such provision, which is Section 6, subsection 6, is subject to the other provisions of the Constitution. And so Nikitobi held that adopting this mechanism means that Chapter 2 is no longer a toothless bulldog that can only bark but not bite. And so the court basically took inspiration from other jurisdictions, notably India and South Africa. In India, the popular case is Maneka and Union of India. And what happened in that case, the court held that the right to life, cannot be guaranteed unless other things that had dignity to that life is provided. What are the other things that had dignity to life? They include water, shelter, food, education, transport, and amongst other things. And you look at the case of JP against the state of Andhra Pradesh, it held that the right to education is quite important and is a logical extension of the right to life. Also in South Africa, if you look at the case of government of South Africa against Irene Grootboom, the fact of the case was that a slum was demolished by the government in order to, build some other structures. And so the court held that there was a duty on the state to guarantee the right to housing for the citizens, which in quote is a socio-economic and cultural right if they've destroyed their slums. So the essence of all these cases I've mentioned is that the courts have determined that civil and political rights cannot be guaranteed without also guaranteeing the socio-economic and cultural rights. I hope you understand. However, in Nigeria, a recent twist has been added to all this discussion. And that recent twist has roots in the African Charter on Human and People's Rights, also known as the Banjul Charter of 1981. And in that charter, there was no dichotomy as we currently have in our 1999 Constitution, where the civil and political rights contained in Chapter 4 is bifurcated from Chapter 2 of the same Constitution, which provides for socio-economic and cultural rights. But the African Charter on Human and People's Rights lumps it together and only provides for one corpus of rights. If you look at the 68 provisions of the African Charter on Human and People's Rights, you will find that it lumps it together. And the African Charter on Human and People's Rights has been ratified and domesticated by Nigeria pursuant to Section 12, subsection 1 of the 1999 Constitution. And it has been domesticated by the African Charter on Human and People's Rights Ratification Act, in Nigeria. And by virtue of the case of, or on the authority of the case of Abacha and Fawemi, the courts have held that the African Charter on Human and People's Rights is now enforceable or has effect in Nigeria. So what do we have? We have the Constitution on one hand saying that there is a dichotomy, and Section 6, subsection 6 of the same Constitution is saying that it is non-justiciable, and we have the African Charter saying that, okay, all these rights are one, and one cannot be interpreted without the other. And so we need to look at a case that interpreted the African Charter on Human and People's Rights, and that case is Bemre and Shell PDC, or Bemre versus Shell PDC. So the court held that the flagrant gas flaring by oil companies is a breach of the right to environment pursuant to Article 18 of the African Charter. So it means that the courts are finding ingenious methods of adopting or deploying fundamental objective and directive principle for what Wise CJN as it then was described as breathtaking possibilities. So as a form of recap, there are several ways, while the general principle or the general notion or the general authority is that fundamental objective and directive principles are non-justiciable, that is not absolute, as it can be justiciable in some instances. One, if there is another section in the Constitution that makes such a provision in Chapter 2 to be, it gives it life, so to speak. You can compare Section 14, subsection 3 of Chapter 2 of the 1999 Constitution with Section 147 of the same Constitution on federal character. Also, such provisions in Chapter 2 can also become justiciable by virtue of the African Charter, which has been ratified and domesticated, and which our courts in Abacha and Faremi have held to be enforceable in Nigeria. And it can also be enforceable at the international fora, where you have different enforcement commissions, for example, the African Commission. And the African Commission in Serach and Nigeria held that the rights of the Ogoni people to health and the rights of the Ogoni people to their environment, pursuant to Article 12 and Article 18 of the African Charter, has been breached by the Nigerian government, and the various remedies were provided. So thank you for watching this video. If you have any questions, please leave them in the comment section. Do not forget to subscribe to this channel to learn more about constitutional law from me. Thank you.